Hi, I'm Misha Ketchell, editor of The Conversation. For democracy to work, people need to be well informed. That's why we work with academic experts to share their research and explain issues in the news. Everything we do is free to republish, but we need your support. Please donate to The Conversation by going to donate.theconversation.com or following the link in the show notes.
In democratic systems, the courts are a vital check on a leader's power, with the ability to overturn laws, and in Donald Trump's case, executive orders, which is all rather annoying if you're a would-be autocrat.
I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policy.
So how has Trump tried to get around these legal guardrails? And can the system be bent to one person's will? I'm Justin Bergman, the International Affairs Editor here at The Conversation in Australia, and this is The Making of an Autocrat. Episode 4, Beat the Courts. Paul Collins, you're a professor of law and political science at the University of Massachusetts-Amherst, and you've been watching the Trump administration's interactions with the Supreme Court closely. Trump has been in and out of the courts for a long time, both as a defendant and someone who likes to sue his opponents. Talk me through how Trump has used the courts to his advantage in the past before he became president, or simply disregarded them.
So as you said, Trump has a very, very long career of involvement in litigation. When he was a private business owner, he frequently found himself in the legal system for a variety of reasons, but he sort of developed this really interesting technique that he still uses today, which is to say he often attacks people, sort of tries cases in the court of public opinion. He delays. And we see this in a lot of his actions, both as president and as a private citizen. In short, Donald Trump doesn't really have a great deal of respect for the rule of law. And as president, he adopted many of these strategies. And one of the most notable ones is that, unlike pretty much every president in American history, he personally attacks judges, sometimes even their families.
We have bad judges. We have very bad judges. And these are judges that shouldn't be allowed. I think at a certain point, you have to start looking at what do you do when you have a rogue judge?
And what's happened is that those judges have faced violence, faced the threat of violence. And this is a very, very new phenomenon in America. Prior to Trump's first term, it was very rare for judges to have many threats of violence. Now it's very, very common.
And how does Trump's relationship with the court differ from other presidents before him?
So most U.S. presidents have had a very healthy respect for the separation of powers, and they viewed the Supreme Court really as a co-equal branch of government, right? An entity that they have to work with. Certainly, previous presidents haven't had expectations that justices, even justices that they've appointed, would rule in their favor or owe them something. This tradition of respect for the Supreme Court in a sort of hands-off attitude was started really kind of at the founding of the country. Thomas Jefferson actually had a bit of a hostile view of the Supreme Court. He floated ideas of even impeaching Supreme Court justices who he didn't appoint. Basically, Jefferson wanted to pack the Supreme Court. But we established in that early era that we're not going to impeach Supreme Court justices who make decisions that the president doesn't like.
So you've been keeping a close eye on two major Supreme Court cases. They're coming up soon in the next couple months. Can we talk a little bit about why these are so pivotal?
The first implicates his tariff policy, and the second is actually a series of cases related to the president firing executive branch employees. So it seems likely that the Trump administration isn't going to fare well in the tariff case. It seems very likely that even the court's conservative justices are going to rule against the Trump administration. There's a couple different ways they can do that. One, for example, Chief Justice Roberts suggested that a tariff was ultimately a tax on the American people, and that's a power of Congress, not the president. There's also a more technical argument about whether or not the act in question even gives the president any tariff authority. There's also a group of cases that are really important to the president's agenda for a different reason that involve the extent to which the president can fire federal government employees without cause. And the employees in question here range from rank and file, kind of everyday federal bureaucrats, to very high-ranking executive branch officials. And part of what Trump's trying to do is get rid of these people in order to basically make the agencies that they work for kind of grind to a halt. But it would also allow him to replace those folks with loyalists to the Trump administration.
Can we talk a little bit about the background here? Why Trump is trying to expand his executive power through the courts in this way?
So first of all, the U.S. is in this undesirable situation that Congress is basically gridlocked. And so the only way for Trump to get through most of his agenda is to do it through executive orders and through the power of the presidency. The other thing that's going on is that the conservatives on the current Supreme Court are very deferential to the president on a lot of issues. And where this deference comes from is this thing called unitary executive theory. And it's basically this idea that essentially all of the power of the executive branch resides in the president of the United States. And so as long as the president has some authority to do something like fire an executive branch employee, the court's going to be okay with that. It's all about presidential power. And that's really, really significant because it's going to enable the president to basically inject a level of politics into the federal bureaucracy that we frankly haven't really seen before in the U.S.
We'll be right back.
I'm Gemma Ware, host of the Conversation Weekly podcast. Each week, I speak to an academic expert about a topic in the news to understand how we got here. From global politics to the latest scientific breakthroughs or the big dilemmas facing our planet. My guests draw on their deep research knowledge to pull out what really matters so that you can understand the context without the spin. Follow the Conversation Weekly for new episodes every Thursday wherever you listen to podcasts, and read more stories on theconversation.com.
So, Paul, let's talk about this idea of a unitary executive theory. This predates Trump, right?
Yeah, so this is it's not the oldest idea in the world. You know, it's been talked about in the last few decades, and it really arrives out of the conservative legal movement, and in particular, the Federalist Society. And the Federalist Society is probably, the most powerful organization in American politics that no one's ever heard of. And what this is a network of lawyers, politicians across the country. They claim to have more than 70,000 members. And, what unites them is a belief in conservative principles and really in the Republican Party as well. And so Trump has been able to leverage some of the ideas that the Federalist Society has to further his agenda, right? Donald Trump doesn't, somebody had to tell him what unitary executive theory was. Donald Trump is not a legal scholar, right? The Federalist Society sort of alerted him to these ideas and, through his appointments on the Supreme Court, through existing members of the Supreme Court, he became aware fairly quickly that they were likely to back a lot of his agenda.
Is Trump following a playbook here? Have we seen this before? Other autocrats taking on the judiciary in this fashion?
Hugo Chavez in Venezuela comes immediately to mind.
Jugando el rol que le ha impuesto el imperio norteamericano.
Autocrats often find themselves in conflict with courts. And this primarily happens when authoritarian regimes come into power, and they often find that they're facing a judicial branch that's not friendly to them, right? In other words, that they didn't appoint the incumbent judicial branch. So there's a couple really significant things that Chavez did. In 2004, he signed a bill passed by a Congress, which his party controlled, that expanded the Supreme Court from 20 to 32 justices. And what that enabled him to do was pack the court with loyalist judges. And these judges supported his agenda. They openly rejected the principle of the separation of powers system. And another really significant thing that Supreme Court did was they went about purging lower court judges who weren't loyal to Chavez. And they were able to do this because in the Venezuelan system, the Supreme Court oversees the appointment and removal of lower court judges. And it's about 400 lower court judges were fired or replaced by the Supreme Court. That same Supreme Court that was loyal to Chavez, was loyal to Chavez's self-appointed successor and his vice president, Nicolas Maduro. And in 2024, they ruled that Maduro won the presidential election despite pretty significant evidence that his opponent garnered the most votes.
Chavez also went after individual judges. Can you talk about that a bit?
The story of Judge Maria Lourdes Afayuni is a really tragic example of this. And so this story begins when Judge Afayuni sort of grants some conditional freedom to one of Chavez's political opponents who was spent about 3 years in prison awaiting trial. And this idea of having really lengthy pretrial detentions, we see that in authoritarian regimes. It's sort of this idea that the process is a form of punishment, that even if you're found not guilty, for example, we can put you in prison for sometimes years at a time. And so what happened with this opponent of Chavez is that he was held in prison for about 3 years, and Judge Afayuni said that, that's just too long. Venezuelan law doesn't permit that. And she also followed a recommendation by the United Nations Human Rights Monitors to release him. Well, not surprisingly, Chavez didn't like this. He went on national television. He called her a criminal.
Que meterle pena máxima a esta jueza y a los que hagan eso, 30 años de prisión.
In a televised speech, Chavez said the maximum sentence must be leveled against Judge Maria Lourdes Afayuni. He said she deserves 30 years in jail to preserve the dignity of the country.
And what happened is that Judge Afayuni herself was held in pretrial detention. And during that pretrial detention, she received death threats while in jail. She suffered physical abuse. Indeed, her lawyer confirmed reports that she was raped while in prison. She became pregnant and had an abortion. And this led to other health problems for her. So the story of Judge Afayuni is really a tragic example of what can happen when authoritarians go after judges. Francisco Franco in Spain is another good example. And Franco ruled over Spain from 1939 to 1975.
Armonizará en España el funcionamiento de todas las capacidades y energías del país.
And he took a slightly different tack to leveraging the courts for his political gain. And what he did was he shifted the power away from ordinary courts to military tribunals. They could essentially indict anything deemed politically subversive as this form of terrorism. And just to give you a sense of how broad this is, the law was defined so loosely that bank robbery could fit under terrorism, or insults or offenses to the Spanish anthem or the Spanish flag. And it's estimated that about 15% of the Spanish population was subjected to these military trials. And to be clear, this was a charade. These trials generally lasted a matter of minutes. The accused were granted almost no rights, and they were just pretty much summarily found guilty of whatever it was they were charged with.
Autocrats rarely find themselves jailed. Are we heading towards a situation where future U.S. presidents may be immune from criminal prosecutions?
I think they already are. The Supreme Court has basically immunized President Trump from any type of criminal prosecution. They basically provided presidents with a shield. That is to say, they can claim that they did something illegal under their official authority, and they're not going to be criminally prosecuted. I have absolutely no doubt that President Trump has taken the Supreme Court's decision and interpreted it to mean that he's basically bulletproof in terms of criminal prosecution.
So really, the coming months are going to be extremely important for how much power Trump is going to be able to wield and how much power he'll be able to exert over the courts.
Yeah, I mean, the Supreme Court is giving Trump all of this authority, but they're giving it to the president, and there's going to be another president. And, it's going to be fascinating to see how future presidents take the power that the Supreme Court gave Trump and utilize that power. And just to give an example, the next Democratic president of the United States could undo pretty much everything Trump has done through executive orders with the stroke of a pen, right? It's literally that easy. That's why governing through executive order is usually considered the sign of a weak president.
And just looking ahead to a post-Trump world, what does this weakening of institutions mean? Do the U.S. courts rebound?
Traditionally, the U.S. Supreme Court has been able to rebound a little from unpopular decisions. It seems that the Supreme Court is not doing that right now. We often draw an analogy that the federal courts have this reservoir of goodwill, basically that the American people have a lot of faith in them. And from time to time, the federal courts can make unpopular decisions, and that reservoir will fill back up. The reservoir is not filling back up right now. And part of the reason why the reservoir isn't filling back up is because of unpopular decisions, but it's also because President Trump is himself depleting that reservoir by criticizing judges, by politicizing the legal process, by prosecuting his political enemies. Trump is really taking a page out of the authoritarian's playbook here. He's showing a real lack of respect for the separation of power system. I think this is going to be quite difficult to course correct for the next president, for maybe the next several presidents, because once these norms start to be destroyed, in terms of separating the branches of government, it's very, very hard to get them back.
Paul Collins, it's been great chatting to you.
Thank you so much. I really appreciate the opportunity to talk.
You can read more from Paul Collins at The Conversation. This episode was produced by Isabella Podwinski, sound designed by Michelle Macklem. Our head of audio is Gemma Ware, and our head of editorial innovation is Ashlyn McGee. Misha Ketchel is the editor of The Conversation Australia, and Stephen Kahn is the editor-in-chief of The Conversation UK. The Conversation is a not-for-profit media organization. You can sign up to our free daily newsletter by clicking the link in our show notes. You can also listen to more of our shows wherever you get your podcasts.
Lovely to have you all here in the flesh.
Hi, I'm Ashlyn McGee from The Conversation, and this is our daily news conference.
Basically, there are only about 4 experts in the country that actually model how much it costs to raise a child.
This is where our experienced team of journalists pitches ideas about what's going on in the world, the latest research developments, or stories that just help you make sense of breaking news. We then hit the phones and keyboards, commissioning academic experts to share their knowledge in stories that are free to read and free to republish. Please consider becoming a monthly donor and support our work. Go to the link in our show notes, donate.theconversation.com, and support a healthier democracy.